Yeah, we'll do the scanner on the partnership act. See, this question came so many times in the exam beta. Whether group of persons is or is not a firm, or whether person is a partner or not a partner in a firm. Explain mode of determining the existence of partnership. Whether it is a partner or not, whether it is a partnership or not, how to decide. He's asking the essentials of the partnership. So there must be agreement, there must be sharing of the profits, there must be mutual agency, there must be lawful business, there must be two or more persons. I think my essentials date question beta. Second question, state giving the reasons whether following are the partnerships as per Indian Partnership Act. He is giving the three examples beta, whether it is a partnership or not. First question, X, Y, Z agreed to share X, Y, and Z agreed to divide the profits equally, but the loss, if any, is to be borne by X alone. Is it partnership? So X, Y, Z, they will take the profits. They will take the loss are there. No, only X should take the loss. Is it partnership? Sharing of the profits does not mean sharing of the losses. Answer is yes, it's a partnership. Next, clear beta. X, a publisher, agrees to publish a book at his own expense, written by Y. Rajini wrote the book and publishing the book. Who is spending the publishing expenses? SG only. X, a publisher, agrees to publish the book at his own expense, written by Y, and to pay Y half of the net profit. Does that create the relationship of partnership between X and Y? X and Y. Will it create the partnership? No. Some other question is popping. Yes sir, no sir. It is not the partnership because there is no mutual agency. Whether he is spending any expenditure? No. Then sole trading business. I am selling, I am publishing the book, I am selling the book. I am giving you every person who shares the profit may not be partner. We discussed. Yes sir, no sir. Seller of the goodwill. Seller of the goodwill. Last question. A D purchase a tea shop and incur additional expenses for purchasing the utensils, etc. Each contributing half of the total expenditure. A and B buying the one tea shop. A and B buying the tea shop. 50-50 they're spending to buy. The shop is leased out. Whether they're doing the business? No. They're giving it on the lease. They're giving it on the lease on daily rental, which is divided between the both. Does this arrangement create a partnership between A and B? So, off death of the Gopal sons, they're having a building. No, they give it on a rental basis. Which basis? They're taking the half of rent. But they're the partners. They are not the partners. Co-owners. So it is not a partnership. It is not a. They are just co-owners. One shop is there. Jointly purchase the shop. Are they doing the business in that shop? No, they're leasing. Then if they are doing the business, sharing the profits, mutual agency is there, then it is a partnership. Yes or no, sir? He's giving the 5 points here. A and B buy a commodity X agreed to sell the commodity with sharing of the profits equally. Business is there, sharing of the profits is there. So assuming mutual agency also there, it's a partnership. It is a then next two firms having several partners combined by agreement into one firm. Can two firms enter into partnership? No. Partners of the two firms? Hmm? Two firms, X and associates, Y and associates. Here six partners are there, here six partners are there. Can they form new partnership? Yes. Answer is yes. Two firms can enter into partnership. Partners of the two firms can enter into next. A and B co-owners agreed to conduct the business. Agreed to conduct the and share the profits. Business is there, sharing of the profits also there. Agreement also there. It's a partnership. It's a done. Next fourth one. Some individuals form an association to which each individual contributes 5,000 rupees annually. The objective of the association is to produce the cloth, distribute the cloths, charity. In business, is it partnership? It is not a partnership. It is not a, because they're distributing. A and B co-owners share between themselves rent derived from the piece of land. For land is there, they're giving on the rent. Both A and B taking half of the rent. Is it partnership, joint ownership, or co-ownership? It's a co-ownership. Business is there, it may become partnership. Next question. Partners indeed virtually embraces the character of both principal and I am agent, I am also principal. I am the agent, I am also principal. What is this? Mutual agents. Which agency? I am acting as agent come principal. Agent come. To discuss the statement. We should write everything about the mutual agency. Done. Clear? Third question. Next, kitna बार? How many times? So many times. What is the conclusive evidence of partnership? What is conclusive evidence of partnership? Mutual agency. Which agency? And state the circumstances when partnership is not there. Four conditions. What are them? Don't maintain the books of accounts. Don't don't maintain the don't retain the terms. Don't maintain books of accounts. Don't opening books of account. And don't inform it to ROC and not inform it to government. Deputy governor. Next, HF versus partnership. Direct question better, but came so many times. How many times? HF versus partnership. Direct question. Next term. HF versus partnership versus co-ownership. Partnership versus company. So came 3-4 times. Direct question. Next question beta. Listen carefully. Listen. Mr. Ram and Rahim are working as teachers. Who are Ram and Rahim? In a Isha Varchand Vidya Sagar Higher Secondary School. So Ram and Rahim are the teachers in a school. Who are the businessmen? The teachers. They are also good friends. Ram and Rahim are also good friends and good teachers in a school. Jointly purchased a flat. Jointly purchased a flat which was given on rent to John. Yes sir, no sir. Who are the Ram and Rahim? Co-owners, joint owners. The owners are? It was decided between the landlord and tenant that the rent would be 10,000 rupees per month, inclusive of the electricity bill. How much is the rent? Including the bill, electricity also. Who will pay the electricity bill? Owner. That is Ram and Rahim. మొత్తం బిల్ 10,000 ఇవ్వన్నారు నెలకు బిల్లు మీరేం కట్టుకోవడం అవసరం లేదు సో ఓనర్ will pay the bill. It means electricity bill will be paid by the landlord. The landlord by mistake did not pay the electricity bill for the month of the March 2023. Due to this, electricity department cut the connection. Mr. John has to pay the electricity bill of 2,800 and 200 rupees penalty to resume the electricity connection. John claimed 3,000 rupees from Ram, but Ram replied that he is liable only 1,500. Mr. John said that Ram and Rahim are partners. Whether they are partners? No, they're joint owners. Which owners are? Therefore, he can claim only 1,500. So, how much John can claim from Ram? Only 1,500. So, how much is the electricity bill? 3,000. How much Ram has to pay? 1,500. How much Rahim has to pay? 1,500 only. The joint owners, but partners, right? आप अलग मैं अलग partners means both are the same. Done. So here, how much is liable to the Ram beta? Only 1,500. Miss Lucy, while drafting the partnership deed, taken care of few important points. What are those points? She want to know list of information which must be part of partnership deed. Is asking the contents of the partnership deed. Contents of पूरा लिखना बेटा. Pick up star also, right? BVIM. BV? आराम. क्या Third question, better contents of the partnership deed. The same question came so many times. How many times? What is partnership deed? What are the contents of the partnership deed? Third question. Remuneration when the agreement is silent. Remuneration of the partners when the agreement is silent. And this question was asked in 2024. Moni and Tony were partners of Measures Moto Company. Moto and Company. They admitted Sony as a partner in the firm, and he is Sony's she kaadu he. Okay na. Her name is Sony. His name is Sony. Why? Just like that. వాళ్ళ మమ్మీ అలాగే పెట్టింది. So who are the partners? Moni, Tony. So recently Sony also came. Moni, Tony, Sony. Sony recently came. So they admitted Sony as a partner in the firm. He is actively engaged in day-to-day activities of the firm. So Sony is the active partner. Which partner? There is tradition in the firm that all active partners will get monthly remuneration of 20. Sony is working, Tony is working, Moni also working. But these two are partners for so many years. As per the business tradition, active partner should get 20k. How much? After admission of Sony in the firm, Moni Tony continued getting the salary from the firm, but no salary was given to Sony. Is it right, beta? ऐसे कर सकते हैं? नहीं करना बेटा. Sony is also working. Yes, sir, no sir. Sony is male, not female. Ganesh, don't get exact. Sony claimed his remuneration, but denied by existing partner, saying that there is no express agreement. When the agreement is not there, no act is applicable. As per act, every partner should take. Done, na? So whether under Indian Partnership Act, Sony can claim the remuneration? Answer is yes. Sony is also active partner. Pellam pillallera Sony ki. Unnar. How many? How many? So Sony is entitled to get the remuneration. Whether minor, whether a minor may be admitted to business of the partnership firm, expand his rights. That question. Minor as a partner. Done. Master X introduced to benefits of the partnership. Master means minor. Benefits of the partnership form of measures ABC and Co. With the consent of all partners after attaining majority, more than 6 months elapsed. Expired. 6 months is expired after becoming major. He fails to give public notice. Fails to give. I kept start. If public notice is not given after expiring the 6 months, he is deemed to become the partner. So, minor is there, minor partner is there. After becoming major, within 6 months, he is not giving any notice. As whether he is elected to become or not to become the partner of the firm. Later on, Mr. L supplied material to ABC and Co. and filed a suit against ABC and Co. for recovery of the debt due in the light of the Indian Partnership Act. Explain what is the extent of what to what extent X will be liable if he fails to give public notice after attaining majority. Is continuing as a partner, he will be liable to L along with all other partners in profit sharing ratio. A ratio? Can L recover the debt from X? Yes, because X is continuing as a partner on attaining majority. देखो कितना बार है एग्जाम में. How many times? So hope you understand the importance of the scanner. इसको यूज करके पी लेना बेटा. यूज करके पी लेना. Still, I don't want to revise. I will sleep only. I can't do anything, Ganesh. Whatever it may be. Though a minor cannot become a partner, he can nonetheless admit it to benefits. Generally, minor cannot become a partner, but minor can also become the partner. What are the cases? He is asking, referring to provisions of the Indian Partnership Act, state the rights that can be enjoyed by minor partner and liabilities of minor before attaining, after attaining. Is asking everything better. Quran declared. I kept so many stars. Same question. कितना बड़ा minor? 1, 2, 3, 4. 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 times I with a minor as a part. How many times? 17 times. Partner by holding what? Partner by stars. Hmm? Yeah. XU, YU are partners in a partnership firm. XU introduced MU. An employee asks his partner to ZU. Who are the partners? XU, YU are the partners. MU, what about MU? Is employee. MU is an employee. But XU introduced MU as his partner to ZU. They said to ZU, saying that MU is also partner. MU is also a. That what MU should say? Hey Babu, I'm not a partner. I'm not a. I'm employee. You should tell I'm not whom employee. MU remains silent. MU remain. What does it mean? Implied acceptance. Implied. MU become partner by Istro. Partner by MU remains silent. ZU trader believing MU as a partner supplied 50 lakh tabs to form on creditor. After expiry of the credit period, ZU did not get the amount of laptop sold to firm. ZU filed a case against XU and MU for recovery of the price. Whether MU is liable? Yes, because MU become partner by SW. Partner by. Then same example we discussed, right? In the place of employee, I said it is a friend. Done. Follow. Same question, beta. Referring to provisions of the Indian Partnership Act, answer the following. Ram, Sham are the partners in the partnership firm. Ram and Sham are the partners. Gaurav, a renowned businessman, is their common friend. Who is the friend of the Ram and Sham? Is not a partner. Ram introduced Gaurav to Sahil, a supplier of the firm, as his newly joined partner. Gaurav, knowing that he is not a partner, he remained quiet. He remained. Gaurav become partner by SW. Partner by. The information about the Gaurav being partner of the firm was shared by Sahil with another businessman, Madhav. Next day, Sahil supplied raw material on credit to Madhav, lent 5 lakhs rupees to firm for the short period on the understanding that Gaurav is the partner of the firm. Gaurav is also partner. So Gaurav has stopped. Hey Babu, I'm your friend, but not the partner. Whether he is stopping, will he liable for the supplier? Same question. 18 and 19. Then advice Gaurav whether he is liable to Sahil. Answer is yes. He will be liable. Then clear here. Gaurav will become partner by SW. Partner by X, Y are the partners in the partnership firm. X and Y are the partners. X introduced a manager. Who is a manager? But X introduced X and Y are the partners. But A is the manager. No. X introduced A to Z as a partner. A to Z as A remains silent. A remain. A become partner by S. Partner by Z. Trader believing A as a partner supplied 100 TV sets. 100. Whether A is able to Z or not? Yes. In the place of laptop. Same question. Clear? Z filed a case on the X and A. Z filed a case on the X and A. A and X. Whether A is liable? Partner by stable. Partner by Ebo question laptop. This question is a TV. That is the only difference. Explain the provisions of the Indian Partnership Act related to creation of the partnership by holding of guide question. Estoppel. Any question. Next question. Two, three questions are there. Focus properly. M and NNP were partners in the partnership firm, which was dealing in refrigerators. On 1st October 18, P retired. So who were the partners, beta? M and P. Unfortunately, 1st October 18, who is retired, beta? P is retired. P is retired. But fails to give public notice. So P will become partner by holding out. Partner by notice. After his retirement, NNP visited the trade fair and inquired about some refrigerators of the latest techniques. So even P is leaving, but he is making friendship with whom? MNN. MNX, who was exhibiting his refrigerators. Who is X? Third party. Na? Who was exhibiting his refrigerators with a new technique, was impressed with the interactions of the P, requested for the visiting card of the form. The visiting card also include the name of the P as a partner, even though he already retired. When he is retired, whether he is giving public notice, whether he is liable for activities of the firm, yes, until public notice is given. Mr. X supplied some of the refrigerators to firm and could not recover the dues from the firm. Now X want to recover the price dues only from not only from the firm but also from the P. Whether P is liable because he is not giving public notice, he will be liable. Then he will be liable till the public notice is given. Then same question. PQ are partners in the partnership firm are retired, but without giving a public notice. Whether R is liable, P approaches as electric. Same question, beta. 25, 23, 24, same. 25th. The 8th question, partnership at will, and also particular partnership. Came 4, 5 times in the exam. 1, 2, 3, 4 times in the exam. That question. Who is nominal partner? Who will give only name and fame but not the capital? He will not take the share the profits also. Then with stand of the first topic also. So remaining part will discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. So welcome to the world of law. Yesterday we have done with chapter 2 of the Partnership Act, including revision. We'll do the scanner. है ना? ये देखो बेटा first question came how many times? 1, 2, 3, 4, 5, 6, 7, 8, 9 times in the exam. Nearly 10 times the question came in the exam, beta. Expulsion. Yeah, beta. So I said expulsion is very, very important. A partner can be expelled if the following conditions are satisfied. A partner can be expelled. Following conditions are satisfied. It must be approved by majority. It must be done in good faith. It must be authorized by partnership deed. Before expelling, he must be given reasonable opportunity of being heard. Yes or no, sir? Based on this question is there X, Y, Z are the partners in the partnership firm. How many partners, sir? 3 partners. They're carrying on their business successfully for past several years. How many years, sir? Spouse of X and Y fought in the ladies club on their personal issues. Ex-wife was hurt badly. So the 3 partners are the beta. Ex-wife sweetie, wife cutie. They're fighting in the club, ladies club. Which club? We discussed this example or not? So they fought in the ladies club in the personal issues. Ex-wife hurt badly. है ना बेटा? Wife का wife है ना बेटा cutie. मारा. सर नो सर. तो पापम स्वीटी हट हो गया बेटा. क्या हो गया? हट. एक्स वाइफ स्वीटी हट हो गया. हट. तो एक्स गॉट एंग्री. एक्स को गुस्सा है. क्या आया? हे भाई योर वाइफ इज बीटिंग माय वाइफ. एक्स गॉट एंग्री on the incident and he convinced the Z to expel भाई. उसको ढकेल देंगे बाहर. है ना? खेल दिया. So Z to expel Y from the partnership firm. Y was expelled. Y was from the partnership firm without any notice from Y and Z. Without giving a notice, can we expel Z? Considering the provisions of the Indian Partnership Act, state whether they can expel the partner from the firm. What is the criteria for the test of good faith in the circumstances? Is asking the when we can expel the partner. We can expel the partner if it is there is a contract between the partners done by the majority acceptance. It must be done in the good faith. Before expelling, he must be given a reasonable opportunity of being heard also. Yes or no, sir? So is it valid reason? Because your wife, my wife is fighting, I will remove you. Is illogical. So expulsion of Y is invalid because it is not done in good faith. If Y is doing something wrong, we can expel. है ना बेटा? So how many times question came? But nearly 10 times expulsion. Still it will come again. 10, 11, 12. 12th time. Ram and Co. form consisting of the three partners. How many partners? Sir? Having one third each in the form 33, 33, 33. Share. Yes or no, sir? According to A and B, activities of C not in the interest of partnership. We discussed yesterday. है ना? When customer comes is throwing the gulab jam, beating the customer, misbehaving with customers, sending the customers to competitor shop. Can I expel like that? Can I expel the partner if he is misbehaving with customers? Sending the customer to competitor shop. Can I expel? Activities of CF not in the interest of the partnership firm and thus want to expel the C from the firm. Otherwise A and B. So can we expel the C here? Yes, because his activities are not in the interest of the firm. Same example we discussed. Clear? 12 to 10. So there must be contract. It must be majority. It must be done in good faith. Before expelling, we have to give a reasonable opportunity. So in the case A and B are majority partners, expel the partner only if the above conditions are satisfied. Done. 12, 13, 14, 15th time expulsion. When I'm giving you explanation, I said star, 10 stars. How many stars? If you remember, I kept 10 stars for that expulsion case. Hai we kept 10 stars or not? That's why SG ko sunna beta. XYZ and associates a partnership firm with XYZ are senior partners. Were engaged in the business of the carpet manufacturing. Which manufacturing? Manufacturing and export to foreign countries. They manufacture carpet, they export to foreign countries. On 25th August 2016, they inducted Mr. G as an expert in the field of carpet manufacturing as their partner. So right now XYZ are they're introducing the Z as a new partner. Z is an expert in the carpet manufacturing. G is the expert in the carpet manufacturing. He become new partner, incoming partner. Z is the incoming partner. On 10th January 2018, G was blamed for unauthorized activities and was expelled from the partnership firm with the united approval of the rest of the partners. That means three partners are agreeing, majority partners agreeing. We don't know partnership details authorizing or not, but before expelling, we should give the reasonable opportunity. Then to examine whether action of the partners is justified or not. One should have the factors to be kept in mind before expelling a partner from the partnership. So before expelling a partner from partnership, we have to satisfy the conditions. It must be done in the interest of the firm, and we have to give the notice. He must be given reasonable opportunity to be heard. So action by the expelled associates is justified as was expelled with the united approval in good faith for protecting the interest of the firm. So why we are expelling by offer is unauthorized activities. Which activities are? So it is agreed by majority partners. The partnership bid is approving. If is acting upward to interest of the firm, we shall have to give the notice. Then we can expel a partner. Yes or no, sir? Next. 15, 16, 17th time beta. What the powers the partner who is expelled will cease to be liable to third party for the act of the firm done after expulsion. After, here what is important? After expulsion is important. See, there are partnership. There is a partnership from ABC and Associates. It was formed on 1/1/2020. 1/1/2020. All are active partners. All are, so B is doing something wrong. D is doing something wrong. D was expelled. D was expelled on 6/6/26. 6/6. After 6/6/26, whether D is liable for activities of the firm. See, ABCD are the partners formed on 1/1/2020. All are active partners. Before expulsion, whether he is liable, D is liable for activities of the firm. After expulsion, whether D is liable. Huh? Huh? When I'm asking something, you will get some answer in your brain. उसका उल्टा answer देना. Why? Lakshmi, right? Why? You know the answer. When D is retiring, expelled, 6/6. Public notice is given on 88/26. 88. In this period, whether he is liable or not, even after expulsion, he will be liable. Till public notice is given, because he is deemed to be partner by holding out. Partner by, so continues to be liable until public notice is given. He become partner by S2. But most of the students, what they will write in the exam, after expulsion, he will not be liable. I said specifically, ABCD are active partners. If active partner is expelled, retired, he must give public notice. Which notice? Done. So how many marks? Maybe 2 marks. How many marks? 2 marks. So he will come to home after the exam. He only will make the marks allotment. He will give 2 out of 2. So कितना मिलता बेटा? अंडा मिलता. क्या मिलता? आरा राउंड राउंड अंडा मिलता. बड़ा होना बेटा. Next, partner not to make the undisclosed profit. Partner not to make the duties of the partner. Partner should not make any undisclosed profit. Which profit? If partner is making any profits, he has to surrender it to the firm. Yes or no, sir? We discussed that. So we are selling the goods. Actually, we will purchase from 20 rupees. We will sell it for the 22 rupees. But we are selling for 25 rupees. Extra how much? 3 rupees. Can a partner eat that? Surrender it to firm. Surrender it to XYZ carrying on the business in partnership. XYZ carry on business in partnership business as a merchant trading between Mumbai and London. Wheaton, a merchant in London, is person pair, person name. Why his name is like that? Because his mummy keeping like that only. వాళ్ళ మమ్మీ అలాగే పెట్టింది ఆ పేరుని. Why his name is Sai Ram, Sai Krishna, Sai Tej? Because their mother kept like that. Wheaton, a merchant in London, to whom they send the consignments secretly, allowing to share the commission which he received upon the consignment in consideration of the Z, using his influence to obtain the consignments from him. His Z is liable to account to firm the monies so he received by him. So Z said to Wheaton, I'll give you assignment. You have to give me secret commission, undisclosed commission. Which commission? We have to send it to firm or not, beta? Yes, sir. Can you eat that extra commission? Duty of the partner to account for any undisclosed profits earned by him. Z is liable to account for the undisclosed profits made by him. Done. Yes, sir. No, sir. Angartale? Listening? Next question, lengthy question, beta. Came so many times. How many times? ABC are partners of a partnership firm carrying on the business of construction of apartments. So there is a partnership firm between ABC. These 3 partners construct the apartments. What they construct? B himself was wholesale dealer of iron bars was entrusted with the work of selection of iron bars after examination of its quality. So the three partners are there. What is the B duty? Buying the iron rods. Buying the iron rods on behalf of the firm. Check the quality, check the price, and purchase for construction purpose. So he himself is doing in the iron business. He himself was a wholesale dealer. Which example we discussed for this? Same kind of example we discussed. Sugar. Crop is there, sugar business is there. He's selling the sugar. He's having sugar factory also. Selling the sugar for more than high in market value. Discussed the same example. B, who himself was a wholesale dealer of the iron bars, but entrusted with the work of selection of the iron bars after its quality. As a wholesaler, B is well aware of market conditions. Current market price of the iron bar was for construction is 350 rupees per kg. We already had 1000 kgs of iron bar in stock, which he had purchased before price hike in the market for 200. See, when he purchased 200, how much he is selling for partnership firm? 350. He know the price will increase. Then what he is supposed to do? Being a faithful person, he should purchase at the rate of 200 only on behalf of the firm. But what he is doing? He is buying for himself. Then he is selling it to firm for 350. समझ में आया question? So he know that he is expert in the market. He is aware of the market conditions. Right now, per kg 350. 2 months back only he know that 2 months back the price was 200. He know the price will increase to 350. Double to 350 to 400. So what he is supposed to do? He should purchase on behalf of the firm. But what he is doing? Himself he is buying. Subsequently selling it to the firm for 350. So how much extra is eating? Can he do like that? Partners like wife and husband. They're like Ganesha. ఎట్లుండాలిరా సిగ్గుపడుతుంది వైఫ్ అంటే సిగ్గుపడుతుంది పిల్లోడు. He supplied the iron bars to firm without the firm realizing the purchase cost. Is B is liable to pay the firm extra money he made, or he does not have to inform the firm as his own business. He's asking, since it is his own business, he needed informer, he has to informer. Informer not informer? He should inform. Because it's a partnership firm, no beta. You're not selling it to competitor, you're selling it to your partners itself. Then he has not taken any amount more than the current prevailing market price, that is 350. He's arguing that the price is 350, I'm selling for 350 only. But you know that the price will increase 200 to 350. What you're supposed to do? Purchase for 200 2 months back only. But you're buying for yourself, but not for the firm. It's a kind of fraud only. Assume there is no contract between the partners regarding the above. So, partner derives any profit for himself from any transactions of the firm, he shall account for that profit and pay for the firm. So B is accountable to the firm for the extra money earned by him. Done. Clear. Even this question came how many times? So many times. 1, 2, 3, 4, 5. 3, 4 times I have it exam. Done. Next, rights of a partner. Third question, beta. What are the rights of a partner? What are the rights of a? ये पूरा लिखना बेटा. 13 rights are there, no? फटाफट लिख लेना. कैसे लिख लेना? फटाफट. Came for 4 marks. How many marks? 4 marks. Next, rights of a legal representative. Rights of a partner. ABs are partners in a partnership firm. As per the terms of partnership, did A is entitled to 20%. What is the A share, beta? 20% of the partnership property and profits. So in the property also 20%, in the profits also 20%. Then clear na? If property is 100 rupees, A share will be 20. Profits are 10 rupees, A share will be 2 rupees. A retires. A retiring from the firm dies after 15 days. He retired. उसके बाद वो मर गया. B and C continues the business of the firm without settling the accounts. Explain the rights of A's legal representative. So, what is the rights of legal representative? What are the rights of the A's legal representative, beta? Amma, how much interest? Or they have right to share the subsequent profits. Which profits are interest rate of the until his accounts are settled. What is the share of interest in this question? 20%. He can take the 20% of the profits or 6% interest on the capital. Then I think we kept star here also. We kept star, right? Hmm? So A is legally dependent entitled to 20% of the share of profits or 6% interest on his property, his share of property until his accounts are finally settled. Then yeah, next question, beta. Question number 11. This was asked for 6 marks. How many marks, sir? PQRS are the partners in measures PQRS and Co. A partnership firm which deals in trading in washing machines of various brands. The 4 partners are there. They purchase and sell the washing machine. Okay. Due to conflict of views between Q and P. Q and P decided to leave the partnership firm and started competitive business. Which business, sir? On 31st July 19 in the name of the PQ and Co. In the name of, meanwhile, R&S R&S have continued using the property name PQRS and Co. in which PQR also has the share. Based on the above facts, explain the rights of outgoing partner. Who are the outgoing partners? P and Q as per Indian Contract Act. Comment on the following. Right of PQ to start the competing business. When after retirement, outgoing partner can do competing business? Yes. Can he do? Can he represent as a partner? No. Can he solicit the customers? No. Yes, sir. No, sir. And right of P and Q regarding the share of property. So they have right to get their percentage of profits or the 6% of interest until accounts are settled. Until accounts are so outgoing partner. Which partner, beta? Outgoing partner has right to carry on the competing business. Outgoing partner, but he cannot use the firm name. Don't represent as a partner. Don't solicit the customers until his accounts are settled. He has right to get the subsequent profits or interest rate of the 6%. Done. खत्म आंसर हो गया. So he can do the competing business. Outgoing partner has the right to carry on the competing business of the firm. He can also advertise his business, but may not use the firm name. Represent as a partner. Don't solicit the customers of the firm until his accounts are settled. He has the right to get the subsequent profits or interest rate of the 6%. Done. Clear? Are you able to get the answers before I'm explaining the answers? నేను చెప్పకుండా వస్తున్నాయి యారు ఆన్సర్లు సతీష్ వస్తలేవు వస్తున్నాయి వస్తున్నాయి రావాలి. This question was asked in 24 and 25 twice. I better 3 marks. How many marks, sir? Only 3 marks for this question. Question number 12. Yeah. A and B operate a textile merchant business in partnership. Mr. A finances the business and is leading and is a sleeping partner. Mr. A is giving the finance but is not operating. So A is a sleeping partner, B is a active partner. In the regular course of business, B acquired certain fabric goods belongs to C. However, B is aware that these goods were stolen property. Which property? See here, who is operating? B. B will become agent. A will become because of the mutual agency. A is a sleeping partner. Which partner? But who is operating? B. B will become agent. A will become. So B is buying something from C. C is a thief. C is a B is purchasing from C. We know that he is a thief. B is aware that these are the stolen property. Despite of this knowledge, B proceeds to purchase and sell the same on stolen goods. Moreover, B records the proceeds from the sales to firm's books. So whatever is getting block it. Now A want to avoid the liability towards the C. A want to avoid the, so who is buying? B. Who is buying? B. So from whom? C. So we have to pay the money to C or not? But A said, now A wants to avoid the liability towards the C on the grounds that misconduct by B. A is there, B is there, B is buying from C on behalf of the firm. On behalf of the, he's a thief. He's a thief. B is buying. A said, we will not make the payment to you because you are a thief. Because you are a, can you say like that? Who is liable to C, B, A, na, both? Both. Because B become agent, A will become principal. Done. So, in the light of the provisions of the Indian Partnership Act, decide the liability of A and B towards the C. Towards the then who is liable, beta? If one partner does any activity, whole firm will be liable. उसको बोलते हैं mutual agents. Which agents है? Next we discuss about the implied authority. Which authority? What is the meaning of implied authority? And point out the extent of the partner's implied authority in case of emergency. Is asking the both. What is implied authority and partner's authority in emergency also. This is implied authority. And this is partner's authority in emergency. Is asking the both. Done. So how many stars are there? So many stars. Are there or not? Dead question beta. ये पूरा लिखना, ये पूरा लिखना. Dead question. What is the meaning of implied authority? What are the starter restrictions on implied authority? Starter restrictions on the implied authority. What is implied authority? Restrictions on the implied authority. We kept so many stars. How many stars? Yeah, this question was asked once, twice, third time, fourth time, 5 times in the exam. How many times, sir? 6 times. 7 times, 8 times. Nearly 8 times happened. How many times, sir? 8 times. So, Mahesh, is there now? Next question. Yeah. Mahesh, Suresh, Dinesh are the partners in the trading firm. Mahesh, without the knowledge and consent of the Suresh and Dinesh, borrows himself 50k from Ramesh, a customer of the firm, in the name of the firm. In the name of the, whether borrowing is within the implied authority or not. Borrowing is within the authority. If one partner does, who will be liable? Whole firm will be liable. So, who are the partners? Maheshu, Sureshu, Dineshu, and associates. So, who is borrowing? Without the knowledge of the donation? Mahesh. Who is buying, purchasing? Mahesh. To whom? Ramesh. What he is doing, beta? Borrowing. How much is borrowing? 50k. Mahesh then buys the goods from the personal with this money, using it for personal purpose. Mahesh then buys some goods for personal purpose with that borrowed money. Can Ramesh hold the Suresh and Dinesh liable for the loan? Whether the whole firm is liable or not? Because he's taking the loan in the name of the firm. In the name of the, it is comes within the implied authority. Even one partner is doing, whole firm will be liable. Then he can hold both of them liable for repayment. Then along with the Mahesh. Along with the Mahesh. Clear na? Maheshu, Sureshu, Dinesh are liable to Ramesh. Clear? Next, A, B, C were partners in the partnership firm, A, B, C and Co. The firm is a dealer in the office furniture. A was in charge of purchase and sale. A was in charge of buying and selling is within the implied authority. Within the, B is in charge of maintenance of books of accounts. A is liable, for buying and selling. B is liable for the maintaining of books of accounts, and C is the in charge of handling the legal matters. That is the cases. A is liable for buying and selling. B is for the books of accounts. C is for the legal matters. Recently, though, an agreement among them, it was declared that A will be in charge of maintenance of books of accounts and B will be in charge of the purchase and sales. There is a restriction on the impaired authority. A should not buy. A should not. Avana kana? Same example we discussed yesterday. We rest. Someone is going to somewhere to purchase a nail polish. वो पागल हो गया. We said to him, you should not buy. You should not sell on behalf of the firm. Yes sir, no sir. We informed third party. We not informed third party. Discuss that. SG. If you listen to SG examples clearly, scanner हो गया. That can be foundation, enter, final, law, audit, tax. That's it. ఏంటి నేను వచ్చినావా రావద్దు నాన్న అమ్మో సో A will be in charge of books of accounts, B will be in charge of buying and sell. That means A should not buy. A should not. Previously A is supposed to buy and sell. Now A should not buy and sell. We're restricting the A's authority. Being ignorant of such agreement, third party is ignorant. Whether firm is liable or not, third party don't know about the restriction supplying the goods. Whether firm is liable, restrict చేసినాం థర్డ్ పార్టీ చెప్పినామా చెప్పలే ఫర్మ్ లైబులా కాదు థర్డ్ పార్టీకి సో బీయింగ్ ignorant about the agreement, Mr. M supplied some furniture to A, who ultimately sold them to third party. Referring to provisions of the Partnership Act, otherwise M can recover the money from the firm. Firm is liable or not? Yes, firm will be liable because third party is ignorant. Third party is, if third party know about this, firm is not liable. Firm is not a. What will be your advice in this matter? Restriction on the authority. Restriction on the third party has knowledge of the restriction. Firm is not liable. Third party has no knowledge. Third party has the firm will be liable. Question related to this point. We discussed the examples. Done. M can recover the money from the firm because he is not aware about the restriction. Actually, it is within the authority of the partner. We are restricting the authority of a partner, but we never inform it to third party. Are we able to understand all these questions? Bangartallulu. Effect of notice to active partner. Effect of notice to effect of notice to active partner. We kept so many stars also here, I think. How many stars? Notice to active partner is equal to notice to firm if the following three conditions are satisfied. The notice must be related to affairs of the firm, given to working partner. There is no fraud. There is no. That question beta. दो बार आया ये भी. Liability of the partner and the firm. Discuss the liability of the partner for the act of the firm. Liability of the firm for act of the partner to third parties too. पूरा लिखना बेटा. The whole page लिख लेना. Impaired authority and third parties. Impaired authority and third parties. ये पूरा लिखना. That question. So hope you are understanding how many revisions are required. How he is testing in the exam. Generally, I will tell after my lecture, बार बार पढ़ना, चार बार पढ़ना, वो dialogue है क्या? नहीं. You should do that. ये देखो, everything is ready. This application next. A, B, C are partners in the firm called ABC firm. A with the intention of deceiving the B. A with the intention of deceiving the D. మోసం చేద్దామని. Intention of deceiving the D. A supplier at the office stationery buys certain stationery on behalf of the firm. Buying stationery on behalf of the firm. The stationery is of the use in the ordinary course of firm's business. A does not give stationery to the firm, instead brings it to his own home. So actually shop is a stationery shop only, buying the stationery on behalf of the firm from the supplier, and that stationery is not going to firm, it's going to partner's home. he, instead of bringing it to his own use, the supplier of the who is unaware of the private use of the stationery by A claims the price from the firm. Whether the firm refused to pay the price on the ground that stationery was never received by the firm. Whether firm is liable? Yes, because he's taking the goods in the ordinary course of business. Which business? In the firm name. In the firm name. Whether firm is liable or not? Yes sir, no sir. I don't know what partner is doing. That is none of my business. No. So whether firm is liable? Yes. Firm contents is not tenable. Firm cannot say like that. Firm will be liable. What would be your answer if part of the stationery is purchased by A was delivered to the firm by him, and the rest of the stationery used by him for the private use, and about which neither firm and nor supplier draw. In the both the cases, firm will be liable. First case, whole furniture is taken to partner home. Second case, are the shop are the partnership. But it is purchased in the firm name. Whose name? But farm business is stationery business only. Yes sir, no sir. So once it is going out of my shop to the firm, so third party is not liable. Yes sir, no sir. In the both the cases, who is liable, beta? Because every partner has the authority to buy the goods. Authority to on behalf of the firm. On behalf of the firm. If one partner buys, who will liable? Whole firm will be liable. Then clear? Are you able to understand, sir? Shruti? Mahesh, Suresh, Dinesh. We discussed 50K. We discussed. Next. Misappropriation by misapplication by partners. What is misapplication by partners? This one. Misapplication by partners. I kept a separate chart for that heading. Last heading. Misapplication by partners. Section 27. Section. So first, firm is taking, one partner is misapplying. Partner is taking, partner is misapplying. Still, both the cases firm will be liable. See, explain in detail circumstances which lead to liability of the firm for misapplication by partners. Misapplication by partners as per provisions of the partnership. Direct question, beta. What is the liability of the firm for misapplication by partners? Section 27. Section done. With this, we have done with the scanner of this chapter. So remaining part will discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. Yeah, welcome back, sir. Welcome to the world of law. So we'll do the scan on the registration. First question, beta. What are the consequences of non-registration of the firm? Consequence of this question was asked 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 times. 10 to 11 to 12 times was this question was asked. Effects of non-registration. Effects of what are the effects, beta? Firm cannot sue partner. Partner cannot sue the firm. Partner cannot sue another partner. And firm cannot sue third party. Cannot sue. And they cannot set off amount exceeding 100 rupees. Set off amount exceeding? Yes sir, no sir. Effects of non-registration. This was asked 12 times in the exam. How many times? Second question, beta. The same set of question. ABC and Associates unregistered firm. Which firm? Purchasing some goods worth of 2000 rupees from R. Purchasing some goods from R. ABC has to pay 2000 rupees to R. In whose favor check was issued, which was dishonored. So ABC is given the check is dishonored. So how much ABC has to pay? 2000. At the same time, firm sold some goods to R worth of 1200. So how much R has to give to firm? 1200, because R is buying from the firm on credit basis. Which basis? How much firm has to pay to R? 2000. How much for R has to pay to ABC? 1200. But the firm is not registered. Not registered. Later R sued the firm for recovery of the 2000. The firm contended that since R's owed 1200 rupees to firm, the said amount should be adjusted against 2000. ABC said, I will adjust 1200 rupees, I will pay 800. I will pay only. Can they say like that? No. They can set off only 100. So how much ABC has to pay to R? 1900. How much? How much R has to be? 1100. They can set off only because firm is not registered. Firm is not done. Clear? Same example discuss chesama. The same example we discussed in the regular class. This was asked. Date is missing. Maybe 23 or 24. Next question. The Indian Partnership Act does not make registration of the firm compulsory. Is it compulsory? No, it is not compulsory. Yet, consequences, disabilities of non-registration have the persuasive pressure on the registration. Still, there are some cases where non-registration of the firm does not affect the some rights. Even the firm is not registered. Even the firm is not registered. So, which rights will not be affected, beta? Firm is not registered. Third party can sue the firm. Partner can sue for dissolution of the firm. Accounts of the dissolved firm, share in the dissolved firm. And official receiver of the insolvent partner can sue for the dissolution of the firm and accounts of the dissolved firm, share in the dissolved firm. And they can set off amount up to, I said this will be 2 stars, I think. Then that is this question better. Clear now? Third party can sue the unregistered firm. We can sue for the dissolved firm and accounts of the dissolved firm. Official receiver, we can set off amount up to 100. How much? What is the procedure for registration of the firm? What is the procedure? Beta? Obtain the application form, fill the particulars. 2 stars. How many stars, beta? Stars. Okay, now. Obtain the application, fill the application, verify application, sign the application, file it with the ROC. Done. There's a procedure for registration of the firm. Next question and last question. PQPXYZ are partners of a registered firm. Which firm? Registered. Firm name is A and Co. X died, P retired. X died, X died, P retired. And Y and Z filed a suit on W in the name and on behalf of the firm without notifying the registrar of the firms about the changes in the constitution. A suit is maintainable. But once upon a time it is registered. Once upon a time it is. Later some changes are happening. They are unable to. We have informed the RYF, but not informing the RYF. Still, the firm can file a case. Then this is new point. Registered, unregistered. Once upon a time it is registered. Later some changes are happened. We have informed RYF or not? Yes. But we are unable to inform the RYF. So can the firm file a case? Yes. Because RN registered. We forgot to inform only changes. So समझ में आया बेटा? So who? What are the changes? ये मर गया, ये insolvent हो गया, he retired हो गया, but not informing to ROC. Then these two people continuing, they filed the case without informing the changes to RWF. Still, the suit is maintainable. Suit can be filed by remaining partners, irrespective of in respect of subsequent dealings or transaction, without notifying the rest of the firm. Changes in the constitution of the firm. The suit will be perfectly valid. It was decided that the remaining partner should sue in respect of the subsequent dealings, even the firm is not registered and suit is maintainable. Suit is. With this, we have done with the scanner of the registration of the firm. Done. So next topic will be dissolution of the firm. We'll discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. Done. Welcome back, sir. Welcome back to the world of law and SG. Shall we start? So we'll do the scan on the chapter 4 of the partnership, dissolution of the partnership. The first question. Direct question. Differentiate between the dissolution of the firm and dissolution of the partnership. This question came so many times. How many times? Even 7 marks also. Direct question, firm and partnership. And dissolution, so we kept so many stars also already. Next question. State the grounds on which firm may be dissolved with order of court. With order of, see, we kept 7 stars. How many stars? With order of court of law. See, 1, 2, 3, 4, 5, 6, 7, 8, 9. Nearly 10 times this question came in the exam. Direct question. So the grounds on which court may order for dissolution of the firm, very, very important direct question. Beta. Next, third question. When does dissolution of partnership takes place under the provisions of dissolution of partnership? Dissolution of, so we kept nearly 3 stars. How many stars, sir? Dissolution of partnership. Dissolution of the partnership. है ना बेटा? So we kept different various stars. Yes sir, no sir. Right question. When does dissolution of partnership firm takes place under the provisions of the Indian Partnership Act? Dissolution of partnership firm only. Dissolution of the firm without order of court of law. Without order of court of law. Third question. From here, practical question starts. This question came in the 24th and 24th December, 24th September. RTP. On admission as a new partner, Ashwin agreed to be liable for existing debts referred as old debts of the firm by an agreement signed by all partners, including Ashwin. Examine Ashwin will be liable in a suit filed by creditor against the firm and all existing partners for recovery of the old debts. There are 3 partners are there. But for example, P, C, D. 3 partners existing there. Partners are there. They're supposed to give you 50 lakhs. How many lakhs, beta? Now A coming, Ashwin is coming as new partner. Ashwin said, I will be liable along with you people, I will pay to SG. This agreed by ABCD. Agreed by the ABCD. Whether A is liable, why? My consent is not obtained. Then A will not be liable even he is accepting because it requires the consent of the creditors also. Incoming partner after becoming partner, he will not be liable for activities of the firm before his admission, even he is accepting. Because along with his acceptance, creditors acceptance also required. Done na beta? Question समझ में आया? We discussed the example, same example in the lecture. Creditors consent is necessary, so A will not be liable. A will not be. Next question, fifth question. Rights and liabilities of outgoing partner. Direct question, beta. Rights and liabilities of the outgoing partner. Determinant of a partner. We kept so many stars. Yes or no, sir? After retirement, rights and liabilities. Rights and he will be liable till public notice is given. Public notice is someone having 10% share in the property of the firm. What's the property of the firm? 400 lakhs. So what's the Suman share? 20 lakhs. 10%. Yes or no, sir? So Suman having 10% share in the property of 20 lakhs of the firm retires. Who is retiring? Suman is retiring. Who is retiring? From 31st March 23. The firm continues the business thereafter without final settlement of the accounts between existing and retiring partner and earn the profit of 10 lakhs during the financial year. So in 10 lakhs, how much is share of profit on 10%? That is 1 lakh. Suman in her own interest. Suman means female here. Suman in her own interest and in the absence of any provisions of the partnership firm claimed 3 lakhs. How many lakhs, sir? Can she claim 3 lakhs? Can she claim 3 lakhs? Chuddam. From the firm towards the use of her share in the property and profits of the firm, which was rejected by partners. So how much someone is entitled to get beta? Actually, 6% interest. 6% are the share of profit. Share of which is 1 lakh, which is but share interest in the 6% into 20 lakhs. 6% into ఎంత వస్తుంది 1.2 lakh. Yes sir, no sir. Then but not 3 lakhs. But not the retiring partner entitled to get the share of profits at 6% interest per annum. Then clear is entitled to get the 1,20,000 or 1 lakh, whichever is higher at the option of the retiring partner, but not the 3 lakhs, but not the so interest in his share of property. Here property 20 lakhs into into 6% interest, or profits in the 10 lakhs into 10%, that is 1 lakh. How many marks? 2 marks anta, unfortunately. Exam question beta. You can get on step number 3. Next, MNP are partners in the firm. MNP are the partners in the firm. The firm ordered JR Limited to supply of furniture. So, MNP and associates is there, beta. They're buying something from the JR Limited. JR Limited. P dies. कौन मर गया बेटा? P मर गया. P मर गया. And MN continues the business in the firm name. The firm did not give notice about the P's death to public. Whether public notice is required for death, public notice is not required. Our partners dealing with the firm. The furniture was delivered to the firm after P's death. The fact of death known to them. The fact of death known to them at the time of delivery. So JLM does know about the death of the P. Afterwards, firm become insolvent, fails to pay the price to JR Limited. Whether P's estate is liable beta after death, his estate is not liable for activities of the firm. So whether P is liable to liable, not liable. Whether does it make any difference if JR Limited supplied the furniture to the firm, believing that all partners are alive? Whether you believe it or not, public notice is not required. The property of the deceased partner will not be liable for the liabilities of the firm. Done. Clear? Is it required public notice? Not required. How many marks? 6 marks. Not liable. Peace estate will not be liable. Peace estate will not be liable in the both the cases. Whether you have the knowledge of the death or not, because public notice is not required. What is not required? Clear? What are the consequences of death of the partner? Direct question beta. ये पूरा लिख लेना बेटा. Clear? Clear ना? Ram Mohan Gopal. Ram Mohan Gopal were partners of the firm. During the course of the partnership, firm ordered Sunrise Limited. Same question. In the place of JR Sunrise Island. Sunrise Limited. A Limited or Sunrise Limited to supply of the mission to firm. Before mission was delivered, Ram expired. Who is expired, beta? Ram. However, the mission, however, was delivered to the firm afterwards. Same question. Which one? 7 and 9, same questions. 10th question. ABC were partners in the partnership firm ABC and Co., which was engaged in the business of the trading in the branded furniture. The name of the furniture was clearly, the name of the partners was clearly written along with the firm in front of the head office of the firm as well as the letterhead of the firm. So, who were the partners? ABC. Their names are written on the letterhead of the firm, even outside the firm. ABC are the partners. बोल के लिख लिया. किधर लिया बेटा? On the letterhead and also outside the firm. Clear? The name of the partners was clearly written along with the firm name in front of the head office. In front of the head office as well as letterhead. On 1st October 18, C mar gaya. He passed away and his name neither removed from the list of the partners as stated in the front of the head office nor from the letterhead. C name is not removed from the letterhead and from the name board. Whether she is partner? No, वो मर गया. To respect his partner, they did not remove his name. As per the terms of the partnership, the firm continued the operations with the B and C. So there was a clause in the partnership firm, partnership deed, even partner is deceased, రిమైనింగ్ పార్ట్నర్ కెన్ కంటిన్యూ. అప్పుడు ఉంటుందా ఫర్మ్ ఉంటుందా? ఉంటుంది. లేకపోతే క్లోజ్ అయిపోతారు. సిన్స్ దే ఆర్ హ్యావింగ్ ఏ క్లాజ్, ఫర్మ్ ఈస్ కంటిన్యూయింగ్. The accounts of the firm will settled and amount due to legal heirs of Mr. C also determined on 10th when he deceased beta 1st October. But same was not paid to legal heirs of the C. So, C share of profits we have to pay. C share of profits and property we have to pay to LR of the C. Legal representative of the C. It was not paid. It is determined but not paid. But not done. 16th October 2018, X supplied furniture worth of 20 lakhs to ABC and Co. ABC and Co could not repay the amount due to heavy losses. X want to recover the amount not only from the partnership firm but also from legal heads of C. Whether C is legal heads are liable? Liable? Cheppandra. His estate is not liable. His estate is, even his legal heads are not liable for activities of the firm after his death. After his transfer, including legal heads, LR also not liable. LR also not liable. Unless the above situation in terms of the provisions of the partnership act decide whether legal heads of C can be held liable for dues towards the X. Legal heads of C will not be liable. Even name is not removed because public notice is not required. Done. Clear? Clear? Not liable. Next question, beta. Lengthy question. Sahil, Amit, Kunal were partners in the firm. The firm is a dealer in the office furniture. They have regular dealings with the ABC and Co for supply of the furniture of their business. On 30 June 23, one of the partner Kunal Marga. Sahil, Amit, Kunal. Kunal is deceased. The firm ordered Measures AB to supply furniture for their business on 25th May. When he deceased June, when they ordered May, before death only. When Kunal was alive. Now Sahil Amit continues the business, firm's name after Kunal death. The firm did not give public notice, did not give any notice about Kunal's death to public. Is it required? Not required. The fact of about the Kunal death was known to them at the time of delivery. Same question we discussed. 7th question, I think. Antena? 7th one only na? 7, 9, 11 are same. 7, 9, 11 are same. Then whether this Kunal's LR is liable? Not liable. Will not be liable. Not liable. 7, 9, 11 are same. Then insolvency antanta with reference to provisions of the partnership act explain everything about the insolvency. HR point लिखो तो बस से बेटा. Then next 13th one. State the modes by which a partner may transfer his interest in the firm in favor of the another person under Indian Partnership Act. What are the rights of such transferee? Rights of the transferee. So we kept so many stars, 10 stars. How many stars? During the existence of the firm, he can receive the transfer share of profits, but cannot participate, cannot prepare books of accounts, cannot inspect books of accounts. On resolution, he can receive the transfer as a share of profits, share of assets, so require books of accounts. So ascertain the transferors share of profits and property. Then follow third question beta. States the modes by which partner may transfer his interest in the firm. How a partner may transfer his interest in the firm? By sale, by mortgage, by pledge, by charge. Yes or no, sir? By sale, mortgage, pledge. And rights of the transfer during the existence of the partnership firm, during the dissolution of the firm, during the continuation. So he can't interfere into the books of accounts. He can't interfere into the conductor. He can't require books of accounts. He cannot inspect the books of accounts. He is entitled to receive only transfers profits. During the dissolution, he can receive the transfers, share of profits to property, and he can inspect the books of accounts. And देखो कितना बड़ा है क्वेश्चन. 1, 2, 3, 4, 5, 6, 7, 8 times. Still it's there. 8. 9, 10, 11. Same question. Correct. Next question. A transferor transfer his share in the partnership in the form to B. B is not entitled to few rights and privileges as A. Discuss the brief the points for which B is not entitled. So rights of the transfer, rights of the transfer. Doing the continuation, doing the resolution. Next, Mr. M is one of the four partners of the XY enterprises. He owes sum of 6 lakhs rupees to his friend Z, which he is unable to pay. So he wants to sell his share in the form to Z. Same example we discussed. One firm is there, XYZ and associates. In that firm, M is one of the partners. M has to pay some money to Z. M is unable to pay the money to Z. He transferred his interest to Z. Z is the transfer of the partner's share. Clear na beta? So, what are the rights of Z? Unable to pay. So, set in the accounts. In the letter, the provisions of the partnership act, can M validly transfer his interest in the form by way of the sale? What would be the rights of the Z? What are the rights of the Z? Same question, beta. By sale, mortgage, otherwise we can transfer his interest. So, same question. Measures ABC and Associates is a partnership firm since 1990. ABC were partners since beginning. A being a very senior partner, aged about 78 years. Transfer. A is transferring his share in the firm to his son Pratik, a chartered accountant. B and C were not interested in the M. So who are the partners? A, B, and C. A sold he transferred his share to Pratik. Who is the Pratik? Son of the A. So B and C don't like Pratik. We discussed same example yesterday somewhere. Somewhere. Yes, sir. No, sir. So B and C don't like Pratik. Can Pratik will become the partner? No. Part his rights and liabilities. That's the question. Not interested in the Pratik, join as a partner in ABC and Associates. After some time, Pratik felt that the books of accounts were displaying only small amounts as profits despite a huge turnover. He wanted to inspect the books of accounts of the firm, arguing that he is entitled as a transferee. No, he is not entitled during the continuation. During the However, other partners believe that he cannot challenge the books of accounts. Can Mr. Pratik introduced as a partner? No, he is not a partner. It's a transfer of the partnership. If his father wants to get retirement, a new partner cannot be admitted without the consent of other partners. Here, B and C don't like Pratik. As the advisor help to resolve the issue. Pratik is a transfer of the transfer share. Transfer of the but not a partner. But not a same question, beta, है ना? Able to understand the question, sir? Since SG is there. Can you understand all this on your own? Not that much easy, I think, unless you do more number of revisions. PQR formed a partnership agreement to operate motor buses along with specific routes for the 12 years. How many years, sir? After operating for 4 years, it was observed that the business incurring losses each year. Despite of this, P determined to continue the business for remaining period. Examined with reference to provisions of the partnership, can P insist to continue the business? No. If so, what options are available to Q and R? So continuous loss are then we can approach court of law for dissolution of the firm. Any other partners? Then court may order for dissolution of the firm. We discuss one example, no, beta. Day by day loss are increasing. To 2020 1 lakh, to 2021 5 lakhs, to 2022 10 lakhs loss are increasing. Partner may approach court of law for dissolution. Done. Then the firm may be closed with the consent of all the partners or as per partnership agreement. So court may is the order for dissolution. So if the firm is making the continuous losses. Continuing guarantee. Date question about continuing guarantee is a guarantee given for the series of transactions. It comes to an from the date of the recreation of the partnership form. Date question. 1, 2, 3 times I beta. When continuing guarantee can be revoked from the date of recreation of the form. So what do you mean by goodwill? What do you mean by goodwill? Date question. Settlement of accounts. What are the modes of settlement of the accounts of the dissolved form? How to settle the accounts of the dissolved form? ये लिखना बेटा पूरा treatment of losses, treatment of assets, payment of the firm's debts and partners' debts. I kept 1 star. How many times this question came? 1, 2 times. Next, premature dissolution of the firm and repayment of the premium. Repayment of the, where is that? Here, this one, section 51. So, if partner is admitting for specific period, bringing the goodwill for specific period, 5 years, 5 lakhs. After 3 years, we are closing. So, how much we have written the premium? 2 lakhs. I said no. I hope same example. 5 lakhs only. 3 years only. So, X was entering into partnership in an existing firm, RST and Associates, for the period of 10 years. How many years, sir? And paid the premium of 5 lakhs. And for every year, 50K. Every year, 50K. The firm was dissolved after 3 years because of the insolvency of a partner. Now, X claims the refund of the premium. Whether we have to refund the premium or not, how much we will debit it to P&L account? 1.5. How much is pending? 8.5 we have to return. 3.5. 5 lakhs divided by 10 years ఎంత per year? 5 lakhs divided by 10 అంటే ఎంత? So 1.5 was 10 అనుకుంటున్నాను. 3.5 we have to return. How much better? We debiting how much? 1.5 out of 5. So how much we have to repay? 3.5. How much was bringing? 5 lakhs for 10 years. Per annum 50K. 50K, 50K, 50K. 1.5 we debited to P&L account already. How much is remaining? 3.5. How much we should return? 3.5. Same example we discussed, but 5 lakhs in 5 years. Done. Last question. X and Y partners in a firm. The firm was dissolved on 12th June 22, but no public notice is given. Thereafter, X purchased some goods in the name of the firm from the Z. Z was ignorant of the fact of dissolution of the firm. X became insolvent. Z filed a case against Y. Whether Y is liable? X and Y is there, beta. When it is closed, 12th June. 12th June it is closed. Whether they get public notice? No. They didn't give any public notice. Except purchasing something from the Z on behalf of the firm name. On behalf of the X become insolvent. Z filed a case from the Y. Whether Y is liable? Yes, because they become partner by holding out. Because public notice is not given. Clear? क्वेश्चन समझ में आया? Done with standard of the partnership act. So done with SOGA, done with contract act, done with PA. चले गया. Clear? So have a great time. Enjoy the day. Prepare well. SG signing off. Take care.